Okay. Well, thank you again, Catherine, for inviting us to be here today, and thank you everyone for being here. My name is Jack Reagan-Bogan, and I am the Deputy Executive Director at the Colorado Poverty Law Project. And I am joined, or hopefully will soon be joined, by my colleague, our Managing Attorney, Lauren Rafter. And we are very grateful for your time today and also just for your interest in learning more about the legislative changes that have been made in Colorado over the last 5 years or so, which affect both tenants and landlords. You taking time to be here today and to learn more about these issues and caring about these issues, it really means a lot to us, and we appreciate it. And Lauren, if you're with us, we're just getting started. And if you're able to share your screen and maybe jump to the second slide where we have our mission statement. But to that end, at Colorado Poverty Law Project, our mission is really to prevent homelessness. And we do that by supporting renters and mobile homeowners through free legal assistance, housing navigation, and also policy advocacy. In fact, a big part of my job as the deputy director is really the latter component. So I'm responsible for coordinating our legislative and policy advocacy on behalf of our clients. And Lauren is charged with largely overseeing much of our legal work. Our goals today is for you to find this presentation helpful and informative. So during this webinar, we will go all the way back to 2019 and try to summarize some of the major legislative changes that have impacted landlords and tenants, as well as mobile home park residents. So we hope to cover a lot of ground during this presentation, although we probably will spend just a little bit more time on recent legislation, largely because there were some sweeping bills passed this year, and it may be less familiar to many of you than some of this older legislation that we're going to be discussing. Now, in a second, I'm going to try to turn things over to Lauren to give a bit of a legal disclaimer, if Lauren's able to join. And so she'll talk about how this presentation includes information, but it's not legal advice. I also wanted to quickly add a few of my own disclaimers. First, anytime there are new changes in the law, there are inevitably ambiguities and questions that arise that really can only be resolved gradually as the public and as courts have time to interpret what these new laws mean. So today, we're going to do our best to summarize the laws as we understand them currently, but there may be some questions and some ambiguities that we really can't answer. We can share our thoughts about how courts might decide those issues, but those questions will really only be decided in time as courts have opportunities to interpret the new laws that were passed. I also want to be transparent that the organization we work with, Colorado Poverty Law Project, we do advocate for renters and for mobile homeowners. So our aim today is really to provide objective information that would be useful for all perspectives, landlords, tenants, and other types of housing services providers. But inevitably, there may be some instances where our commentary is informed by our perspective as a tenant advocacy group. Of course, I do want to stress, please feel free to think differently than we do about the merits of these new laws. Anytime there are public policy changes, there is always ample room for reasonable people to disagree when it comes to those matters of policy. No less, we do hope that the information that we provide today, the legal information that we hope to provide as neutrally as possible, will prove helpful for everyone. Now, in a moment, I'm going to hand things over to Lauren, if she's with us, to explain the legal disclaimers. And then we're going to dive into the interesting stuff, starting with 2019 and moving our way into the present. Catherine, if you don't mind flipping to the next slide. Real quickly, excuse me, if there's a slide before that, I just wanted to share our contact information, and we can come back to this at the end of the presentation. Perfect. So the first link that you'll see here is a link to our intake form. So if you know of any tenants or any mobile homeowners who might benefit from our services, whether that be legal assistance or housing navigation, please feel free to keep this link handy. And again, we will never charge anything for our services. So we do have limited capacity, and there are some times where we can't help provide full representation to the degree we would like, but we will always do our best to provide advice and direction and a helping hand to anyone who reaches out to us, and we will never charge anything for it. I also want to include our contact information for both Lauren and myself, because I want today to be the start of a conversation, not the end of the conversation. So please feel free to stay in touch with us. We are here to help answer your questions or to provide resources if we can ever be helpful. Really, please don't hesitate to contact either one or both of us in the future if we can be helpful. And Lauren, great timing. That brings us to our next slide of, if you don't mind going back, Catherine, to disclaimers.
Sure. And Lauren, do you want me to stop sharing and then allow you to share instead so you can have more control?
Do that. I am so sorry, everyone, for my technical difficulties. My computer does not want to work today, but it's great to be here with you all. Let me pull that up.
I'm going to stop sharing just so we can.
And Lauren, you haven't missed any content, but I did just explain a little bit about a background as to who we are and the work that we do and how we might be a resource even beyond today. And so when you have your notes pulled up, we can start off with the legal disclaimers about information versus advice.
Perfect. All right, I have that here. Let me share my screen. All right, can you see the slides here?
We can.
Perfect. All right, so as you know, we are lawyers and we are going to be talking about the law. So we have to give a disclaimer that this is not legal advice. We're not telling you what you or your clients or anyone you know should do in any particular situation, but rather providing general legal information about the laws here. And if you would like to chat with us about your situation or have a client chat with us about their situation, you can absolutely reach out. So we just ask that any questions asked here are hypothetical and not, what should my cousin Mary do if her landlord did this? Because we can't really answer those specific questions just to maintain our privilege. All right, so let's hop right in to 2019. So 2019 was a big year for tenants. It was the first year in a long time where we had a blue legislature. So a lot of the democratic priorities that were longstanding were passed for the first time. And we will hop into each of these individually as we go. We'll have a general screen about all the bills we're going to talk about, and then we'll dive into each one specifically. So one of the bills that was passed this year was regarding bed bugs. We have a warranty of habitability, but the legislature decided this year to make specific regulations around bed bugs and bed bug remediation. So if a prospective tenant requests whether there have been bed bugs in the previous 8 months, they may ask their landlord to disclose that and any information about when it was last inspected and found to be free of bed bugs. Tenants have to notify their landlords if they suspect bed bugs, and then landlords have specific obligations to do. Within 96 hours, they need to obtain an inspection, update the tenant, and if they're found, they have to continue inspecting the surrounding units and begin reasonable measures to treat the bed bugs, not longer than 5 business days from there. Landlords are responsible for costs of inspection and treatment, with some exceptions, and tenants have to comply with reasonable measures to permit inspection and treatment. Another bill that was passed in 2019 was what we call RAFA, the Rental Application Fairness Act. So it creates boundaries and obligations around what a landlord can consider when they're deciding to rent to someone and what they cannot. Landlords have to charge all tenants the same application fee and only the actual expenses that they incur in processing an application. So they can't profit off of application fees. They shall provide itemized receipts to tenants explaining why they are charging that amount. And if they charge, let's say $50, but end up only spending $25, they have to reimburse the tenant for the amount that they did not actually spend. Now, in terms of what they can consider, if they are considering rental or credit history, it doesn't say they have to, but if they are, they shall not consider anything beyond 7 years ago. And again, if they are considering criminal history, they shall only consider convictions within 5 years, with some exceptions for homicide type offenses, sex offenses, production and distribution of meth, for example. And within this, they can't consider any arrests or things that were not actually convictions. So only if the court has found you guilty or you pled guilty. And then if a landlord is denying a tenant, they have to provide them in writing with the reason for that denial so that the tenants know what's going on. And in the future, they can work to address that so that they aren't denied anymore. Anything you would add on either of those two, Jack?
No, you did a great job covering it. Some of these laws have been amended in the subsequent bills that we're about to talk about, including the bill that we're on now, which is House Bill 1170. So this was a bill that updated Colorado's warranty of habitability, which, as Lauren mentioned, it's the law that addresses what is required to maintain safe and healthy rental housing. For today's purposes, I'm going to spend relatively less time on this bill, primarily because there was another major update to the warranty of habitability that passed this year in 2024, and it changed the law considerably, and it rendered some portions of 1170 outdated and obsolete. But no less, I did want to mention this bill because it was really the first major legislative reform to Colorado's warranty of habitability since the original law was enacted in statute, which I believe was back in 2008. This bill, 1170, didn't quite work as the sponsors and as advocates intended for it to work, which is a large reason why there has been subsequent legislation. However, it did include some pretty major changes to habitability. And specifically, it established some timeframes for landlords to at least begin making repairs. It also enacted a requirement that landlords provide either a hotel or an alternative living accommodation in some circumstances where the habitability issue is really serious and it would threaten health or safety of a tenant. This bill also, for the first time in Colorado, established a process in which tenants can withhold rent if the landlord does fail to make the necessary repairs. And then it established some anti-retaliation protections for tenants who raise habitability issues or they raise complaints. Now, again, many of these laws and processes have since been tweaked or changed in a bill from this year, Senate Bill 94, that we'll describe in more detail in just a little bit. But it is helpful to remember 1170, that it came first 5 years earlier, and it laid a foundation for some of the more substantive changes to come later. Next slide, please. Now, one of the most controversial bills from 2019 was House Bill 1118. And this is a bill that extended the notice given to tenants before most evictions can be filed. It increased the time from 3 days notice to 10 days notice. And so this is the time that the landlord must give a tenant to correct an issue, for example, by paying rent that remains owed, before the landlord can then proceed by filing an eviction with a court. At the time that this was enacted, Colorado was in a minority of states that provided tenants with only 3 days notice before the eviction could be filed. And this was proving challenging to tenants for a few reasons, but it was really especially tough for people to access rental assistance or legal assistance in such a short time span, because as many of you know, rental assistance, it generally takes longer than 3 days to review and approve applications and get all the paperwork someone would need to demonstrate their eligibility. As this bill was introduced, it would have required actually 14 days notice before an eviction, and that corresponds with the model legislation from the Uniform Laws Commission. But there was a political compromise that was struck, and that lowered the time frame from 14 days to 10 days, and that's what ultimately passed. I want to mention there are several exceptions and exemptions to this time frame. The first exemption is for very serious lease violations. So those that might threaten someone's health or safety, if someone's damaging the property itself, these types of serious violations in statute are referred to as substantial violations. And it's kind of a term of art, and it's a defined legal term, but it basically means very egregious behavior that would threaten health, safety, or property. And in those cases, House Bill 1118 did not change the time frame. So to this day, those evictions can be filed with only 3 days notice. The second exemption is for landlords who are leasing a single family home. So not an apartment per se, but a house. And when the landlord owns 5 or fewer single family homes, and it's kind of it was meant to be kind of a mom and pop landlord exception. And in those cases, if the landlord is renting out a single family home and they own 5 or fewer, they are only required to provide 5 days notice before the eviction could be filed. However, I do want to note that to qualify for this exemption, there has to be some disclosure. There has to be a disclosure in the lease that the landlord is exempt and only has to give 5 days notice. If they don't notify the tenants, then they would still be beholden to the 10-day notice. The other exception is for employer-provided housing, where the landlord is also the tenant's employer. I think we see this a lot in the ski industry, for example. And in those cases, the landlord is still only required to provide 3 days notice. I also want to mention, we're just talking about residential evictions. This did not affect commercial evictions of businesses. So businesses or commercial evictions are also still under a 3-day notice period. Next slide, please. And the last bill that I wanted to discuss from 2019 is House Bill 1309. And this was really the first major change to Colorado's Mobile Home Park Act in many years. This is a law that I think goes back to 1973, the Mobile Home Park Act. And it has been amended a handful of times over the decades, but not much in the 21st century until 2019 in this bill. Perhaps most notably, this bill authorized state oversight over the Mobile Home Park Act. So it established an administrative process that I'm sure many of you are familiar with because it's within the Division of Housing, and that allows mobile home park tenants and mobile home park owners to seek relief administratively if their rights are violated. This program is called the Dispute Resolution and Enforcement Program, or DREP for short. And it was really meant to be more accessible and a less expensive way for park owners and residents to settle their disputes, short of having to go to court. So to that end, this legislation allowed the Division of Housing to accept complaints from both park owners and homeowners, and it allows the state to investigate, to adjudicate those complaints, and if needed, to issue penalties for violations of the Mobile Home Park Act. Now, the parameters of this program has changed over time. In fact, there has been, I think, at least 3 subsequent bills that have amended this program, and we'll talk about those more in just a little bit. No less, this program still exists, and it's been further refined through regulatory rulemaking that the Division of Housing has facilitated. And it still stands out as one of the few areas where people can seek enforcement over their housing rights short of having to go to court. I will just quickly mention there were a few other policy changes in this bill that are worth mentioning. First, like House Bill 1118, this bill also extended the notice that's required before an eviction can be filed for non-payment of rent by a mobile home park resident. So it increased that time from 5 days to 10 days to align with the other law. This bill also increased the time that's allowed for a mobile homeowner to either move their home or to sell their home after an eviction, from what was only 2 days to what is now at least 30 days. Although people actually have an option of having as many as 60 days to move their home or sell it if they are able to prepay a prorated portion of rent for that additional time. This was a big change because, as you can imagine, trying to sell or move a mobile home with 48 hours was nearly impossible for a lot of people. And we saw a number of folks simply abandon their house and all the equity with it because of that time frame. So this was a policy that was meant to prevent that from happening. And then finally, this bill also expanded the legal authority for counties to regulate mobile home parks within the unincorporated areas of the county. So in sum, I think House Bill 1309 will be remembered historically as a really foundational bill that helped pave the way for at least 4 or 5 subsequent bills that have passed just in the last 5 years. But it's really also notable for creating one of the few areas in housing law where the state has oversight authority. And so this was, I think, in many respects, a precedent-setting bill that aimed to expand access to justice for people who might struggle to navigate the court system. Next slide, please. All right, well, this brings us to 2020. And 2020 was an interesting legislative session. As many of you probably recall, this was a year that was characterized largely by the onset of the COVID pandemic. So this was a chaotic time for pretty much everyone, but including renters and landlords who had to navigate some unique pandemic era policies, both on the federal level and on the state level. The pandemic also shortcutted the flow of the legislative session. And you might remember the session was actually adjourned for a large period of time because of the pandemic. But it did not prevent some significant landlord-tenant legislation from passing. In particular, this was, I think, a big year for fair housing legislation. So policies that are meant to protect tenants from housing discrimination, and also policies that address barriers to housing that tenants face at the onset during the application process. So to that end, there was a bill that addressed housing discrimination based on immigration status. There was a bill to prohibit discrimination based on a person's source of income or their use of a voucher. And there was also a bill that limited public access to certain types of eviction court records. And we're going to discuss all of this legislation, as well as a pair of other bills that built on 1309 in terms of modifying Colorado's Mobile Home Park Act. Now, if I may, Lauren, turn things back over to you so that you can discuss the first 2 of these bills.
Of course. So the first of the bills is the prohibition on discrimination based on citizenship status of the tenants. This created the Immigrant Tenant Protection Act, or ITPA, as we call it. It prohibits landlords from demanding, requesting, or collecting any information regarding the immigration or citizenship status of a tenant, from disclosing or threatening to disclose such information, from refusing to rent to someone based on their immigration or citizenship status, and from attempting to influence the tenant to not seek to occupy a unit. So by saying, oh, you shouldn't actually live here because we aren't fond of immigrants or anything like that. Or you need to leave because I will report you to someone if you don't move out. Or filing an eviction against someone actually going through the process based on their immigration or citizenship status. Now, there are some exceptions here. If a landlord needs to comply with a court order, then they are allowed to disclose such information that they may have. And they also may request SSI information, so a social security number, as long as they request that from everyone, and they are not specifically doing it for folks who they question their immigration status in order to get to that information. And lastly, if they are a landlord employer and they need that information for employment, then they are authorized to ask about immigration status. The next one we'll touch on is the prohibition of discrimination based on your source of income. So similar to the ITPA, this prohibits landlords from refusing to rent or to show a unit to someone based on their source of income. So because you have a voucher, or because you're self-employed, or because you receive child support or TANF or Social Security or anything like that. If it is based on how you are getting your income, the landlord cannot refuse to rent to you. And it includes listing a preference or limitations in advertisements. So even if a landlord doesn't say specifically to someone, oh, you have a voucher, I'm not going to rent to you, they cannot post on their website that we do not accept vouchers or something to that effect. It also prohibits landlords from discriminating in the terms or conditions of a rental agreement against a person based on their source of income or their participation in public housing assistance, so for having a voucher. So they can't give one person who is paying with normal employment income one sort of lease and then give someone who has a voucher a different sort of lease, with the exceptions that, of course, if you need to have a HAP contract or something like that and other like HUD protections or requirements, those can be included.
All right, thank you.
Pass it back over to you, Jay.
Thank you very much. So this brings us to our next bill from 2020, which was House Bill 1009. And this is legislation that sought to promote housing access by limiting public access to eviction court records. As context, prior to this bill, when an eviction was filed, even if it was dismissed, it could still prove to be a scarlet letter for tenants who might be denied a rental opportunity due to that court record. And this was problematic for many tenants for a few reasons, but largely because an eviction filing is not necessarily the same thing as an eviction that was ordered. It's not necessarily indicative as to whether the tenant was at fault or not. There are some cases where we've seen evictions filed completely erroneously against the wrong person, or in some cases, I'm afraid we've seen some filed as retaliation against the tenant. But in many cases, having a prior court record of an eviction filing was not necessarily an appropriate reflection of how that person really was as a tenant, or for predicting how they might be as a tenant in the future. It was a big barrier to people getting housing, and we did see at least some property managers who would decline to consider someone if they had even a filing on their record. So as a result of these issues, legislators passed House Bill 1009, and this bill generally limits public access to eviction court filings. So after this bill was passed, eviction court records are initially kept private when the eviction is filed, and they remain private forever if the eviction is dismissed, or if both parties agree that the record can remain suppressed through a part of a settlement or a stipulated agreement. Otherwise, the evictions that are actually ordered are still then made available to the public. I do want to note this law was amended a few years later in 2022. There was a bill that included some technical changes so that tenants and their legal counsel could still access records when it was needed and at the tenant's discretion. No less, this bill 1009, it was a major change in how eviction court records are handled in Colorado. And for many people, it did eliminate what previously had been a significant barrier to securing stable housing. Next slide, please. All right, well, to cap off our 2020 legislative review, I do want to spend a few minutes discussing a pair of bills that further reformed Colorado's Mobile Home Park Act. And these are House Bill 1196 and House Bill 1201. The former, House Bill 1196, largely addressed substantive rights and responsibilities of mobile home park residents, whereas the latter bill, House Bill 1201, which I'll talk about in a minute, created a new policy that's known as the Opportunity to Purchase law, and that affords mobile homeowners some additional rights to make an offer to purchase their park when it's put up for sale. And for those of you who are interested in political history, I will note that both of these bills were sponsored by former state representative Edie Hooten, who was a representative from the Boulder area. And you might remember her as being an outspoken champion of mobile home park reform. And in fact, one of these bills, 1196, was also sponsored by Representative Julie McCluskey, who is now known as the Speaker of the House, McCluskey. In any case, diving into the policy, House Bill 1196 updated the Mobile Home Park Act in a number of ways. And specifically, amongst other changes, it raised the threshold for what can be grounds for an eviction of a mobile home park resident. It also limited mobile home park rules that might be considered arbitrary or onerous or expensive. And it raised the responsibility for park owners to maintain safe park grounds. This bill also prohibited retaliation against park residents for voicing concerns and complaints, and it established in the Mobile Home Park Act a general right to privacy for homeowners. This bill also created some additional enforcement mechanisms for those who may have had their rights under the Mobile Home Park Act violated. So it expanded options to pursue relief both in court and also through that administrative process that was created a year earlier in House Bill 1309. Now, this legislation was, in many respects, pretty expansive, and we could probably dedicate an entire presentation to just this bill. But for the sake of time, I do just want to mention a few specific highlights. First, this bill provides park residents with more time to cure or to fix issues before they would face an eviction. So it increased the time frame to 90 days in most cases. Although, again, there are exceptions for very dangerous behavior, and those evictions can still happen much more quickly. This bill also limited when evictions can occur for park rule violations, so that people theoretically will not lose their homes for relatively minor infractions, but only when their violation of the rules also implicates significant health and safety concerns. And this bill also further defined the circumstances that can give rise to an eviction when there's certain types of nuisance behavior. This bill capped what can be charged as an allowable security deposit for park residents to not exceed more than 1 month's worth of rent, regardless of how large the mobile home is. And it expanded the notice that residents receive when a park is put up for sale or when it's being closed down and the land's being converted to another use. So it increased that time frame to 12 months so that people can try to plan ahead and find other housing accommodations. This bill also clarified park owners' responsibility to maintain a safe infrastructure and to provide a more transparency in terms of water billing, which was an issue that causing some consternation, at least in certain parts of the state. And then again, finally, this bill established some stronger protections around retaliation so that when people do voice concerns, they would have some protection from rent increases or retaliatory evictions. So in sum, this was really, I think, probably the largest substantive revision of the Mobile Home Park Act since the law was enacted nearly, I guess, 50 years ago. Next slide, please. So the companion bill to 1196 was House Bill 1201. And this bill also modified Colorado's Mobile Home Park Act by enacting a new policy known colloquially as Opportunity to Purchase, or sometimes it's known by its acronym, which is OTP. And this policy provides expanded opportunities for mobile homeowners to pool together their finances and their resources and to put forward an offer to purchase a park when it's put up for sale. Now, we will talk about this policy more in just a few minutes because it was amended by a subsequent bill and a couple of years later. But it's important to note that House Bill 1201 was the bill that first established this unique process of notice and negotiation for mobile home park sales. So under this bill, a park owner who wants to sell their park has to provide advance notice to the park's homeowners. And they also must negotiate in good faith if the homeowners express a desire to make an offer. It doesn't compel the park owner to necessarily accept that offer, but it does require good faith negotiation. This is a little bit in contrast to the next bill we'll talk about in a few minutes that did establish, in some circumstances, a limited right of first refusal when the park residents are working with local governments who's acting on their behalf to put forward an offer. But under this bill, park residents have an opportunity to negotiate, but they don't have the right of first refusal to match the best offer and guarantee their opportunity to purchase the park. I would just say real quickly on 1201, there were some procedural gaps that prevented it from being widely successful, and that was the impetus for the later legislation. But it was consequential insofar as it established this foundation for homeowners to compete with some of the national and international hedge funds that are interested in purchasing mobile home parks. And I would say from a 30,000-foot level, the ultimate goal of this legislation and the opportunity to purchase policy is really about self-autonomy. It's about granting mobile homeowners control over their own fate by allowing them to pursue ownership of their park and thereby allowing them to have control over the direction of rent increases and park rules, and overall just having more say in their park's management. Next slide. All right, well, this brings us to 2021, which on paper, this might seem like a less active session. In fact, you'll see there's only 3 bills from this session that we're planning to discuss today. However, there is a bit more to this than meets the eye, because first, there was a lot of advocacy energy this year that was focused on the federal level and or focused on Governor Polis, since the pandemic was still really in full swing, and there were eviction moratoria, there were rental assistance funding that was being requested, and there were other measures that were being pursued outside of the state legislature in order to help support both landlords and tenants in terms of recovering from the pandemic. The other factor from this year that I want to note is that legislators, I think, were particularly focused on efficiency because the pandemic was such a pressing issue that was commanding a significant chunk of their attention and their time. Legislators were urging consolidation of bills or basically to ease the pressure on the legislative calendar. So as a result, there were several bills that were being drafted that were ultimately consolidated into a single, you might call it an omnibus bill, which is Senate Bill 173. And this is a bill that addressed both eviction court reforms, but it also established a new policy around the imposition of rental late fees. This year also saw 2 other notable bills passed. You see on the slide, House Bills 1121 and also 1054. And so we'll be discussing these bills over the next couple of slides. So as I mentioned, one of the most consequential landlord-tenant bills that was passed back in 2021 was Senate Bill 173. And this again combined eviction court reforms along with regulations around rental late fees. One of the most controversial elements in this bill was the expansion of a tenant's right to cure or a right to pay back their rental debt before facing an eviction order. Under this bill, tenants who do owe back rents were able to pay their debts at any point before the eviction is actually ordered. Whereas previously, a landlord could refuse to accept payments at any point after the eviction had been filed. So again, in large part, this policy was really meant to improve the efficacy of rental assistance because it can often take some time to process rental assistance applications, and that time often stretches beyond the date that the eviction is actually filed in court. Amongst other eviction court reforms, this bill also allowed tenants at least 7 days to prepare for an eviction trial after filing their answer. It used to be that in some cases, the trial was scheduled the same day that the answer was filed, which left essentially no time for people to seek legal assistance or rental assistance. And this bill changed that. So it gives people 7 days to prepare for, if there's a trial, to prepare for that. This bill also allows tenants to file their answer at any time before end of business on the day that it's due. This might seem like a small thing, but it was a pretty big deal, because there were a lot of folks who tried to file their answer at, let's say, 2:30 in the afternoon, only to discover that the court had been closed early, and that they weren't able to file it anymore, and they would receive a default judgment despite making efforts to participate. This bill also it created a process to facilitate the discovery or the exchange of evidence and documentation. This bill sought to expand people's knowledge of available resources by requiring that information about legal and rental assistance be included on an eviction summons. And then finally, this bill allowed tenants to raise some habitability related defenses to certain types of evictions. And it established penalties for situations in which a landlord may illegally lock someone out extrajudicially without a court order. Now, in the late fee portion of this bill, Senate Bill 173 capped what can be charged as a rental late fee. So it capped rental late fees not to exceed the greater of either $50 or 5% of the past due rent. It also established a 7-day grace period before the late fee can be charged. Though I do want to note that it's different from mobile home park residents. This bill actually established a longer 10-day grace period for mobile home park residents. Moreover, under this bill, tenants could not be evicted solely due to unpaid late fees. They can't be charged interest on late fees, and they also have to receive notice of the late fee. It's pretty generous, but they have to receive notice at least 180 days from the date that rent became late or owed. And then finally, and this is not specific to late fees per se, but this bill did generally prohibit leases from including what I describe as a one-way fee shifting clause. So this would be a provision that says that a tenant has to pay the landlord back for legal fees and attorney's fees, but not the other way around. That if the tenant prevails in court, they aren't entitled to anything. And this bill essentially said, no, leases can't do that anymore. Moving forward, anytime there's a fee shifting provision in a lease agreement, it has to go both ways, which means that whoever is the prevailing party in the dispute would be allowed to recover their legal cost. So you can probably imagine why Senate Bill 173 was controversial, because it really did include some major changes in landlord-tenant law and in eviction court procedure. No less, there was, in fact, a companion bill to Senate Bill 173, and that is House Bill 1121. So I will turn things back over to you now, Lauren, to describe what else was included in that legislation.
Right. So 1121, updated language included in the court summons to give some more clarity about what should be expected. And it prohibited a sheriff from executing the writ of restitution. So first, if the tenant loses the eviction case, judgment for possession enters, then a writ of restitution enters, and then the sheriff can use that writ of restitution to actually physically move out the tenant and their belongings if the tenant does not leave first. This bill expanded that time or granted time to the tenant before the sheriff can actually come and move them out. So it stated that at least 10 days after the judgment for possession issues, within those 10 days, the sheriff cannot come. They have to wait at least 10 days before they can come and physically move that tenant out. So ideally, the tenant would be able to move out on their own to avoid the trauma and the hassle for everyone involved. Additionally, it prohibited rent increases in certain ways. So of course, if you have a written lease that says your rent is $1,000 for the next 12 months, your rent is $1,000 for the next 12 months. But if you have a more fluid agreement where it may be a month-to-month lease, this bill required that there be 60 days notice given to the tenant before a rent increase goes into effect. So they have enough time to prepare for that, to get their money together, to ensure that they're going to be able to afford that. And a rent increase can only be given once every 12 months. So if I'm on a month-to-month lease and my landlord wants to increase my rent, they can do so by giving me notice 60 days in advance, and only doing so once within that 12 months. Additionally, it prohibited landlords from terminating a tenancy with the primary purpose of increasing rent without providing that 60 days notice. So I believe the legislature may have anticipated that if a landlord wants to increase their rent, but they don't want to give that 60 days notice, or they don't want to follow these procedures, they can't actually just terminate the tenancy, to either begin it again or to rent it out to someone else in order to get more rent. I'll also touch on the last bill that we're going to highlight in 2021, which is 1054, which addresses public benefit verification requirements. So similar to the ITPA a little bit, unless it is required by federal law, a landlord may not require verification of lawful presence in the United States, or a housing provider may not require that in order to allow that tenant to receive public or assisted housing, housing services, housing assistance, or other similar benefit. So a tenant should not need to prove that they have lawful presence here in order to get support in finding some housing. Anything you would add on either of those bills, Jack?
No, you did a great job covering it. Thank you.
And then I will kick us off for 2022. Again, the legislature did some cool things to move the ball along for our tenants. We have 3 bills here that we're going to highlight, and I will just dive into the first. So along the lines of the other fair housing protections that we've talked about, the legislature made an intentional effort to expand protected classes when it comes to housing. So we had seen a lot of landlords say, I am not going to rent to you because you're a veteran, because I have worked with other veterans in the past and that it did not go well for whatever reason. And so the legislature decided to add veteran status as a protected class in which you cannot discriminate against them in housing for. So you can't decide you're not going to rent to someone because they are a veteran. You can't decide to give them a different lease or treat them differently than other tenants because of their veteran status. And it also gave the CCRD, the Colorado Civil Rights Division, the authority to investigate and adjudicate complaints in this regard to make sure that there was some enforcement mechanism.
All right. Thank you, Lauren. I'll pick up the baton here because I want to dive into another notable housing bill from 2022, which was House Bill 1082. And this is a bill that created a new division, a new office within the Attorney General's office that is charged with enforcing certain housing protections. So under this bill, the Attorney General gained enforcement authority over laws that are related to security deposits, the law that limits consideration of criminal history on rental applications, the law that regulates late fees, as well as laws that Lauren just described from 1121 that require notice and limit the frequency of certain types of rent increases. Also under this bill, the AG's office was charged with enforcing Colorado's Immigrant Tenant Protection Act, which we just described, as well as Colorado's Mobile Home Park Act. I do want to note that there's been some additional legislation passed since 1082 in the subsequent years that has actually added to this list. So the Attorney General's office also gained authority to enforce the entire Rental Application Fairness Act. And then most recently this year, they gained enforcement authority over Colorado's warranty of habitability, at least insofar as they are able to investigate habitual offenders of habitability laws. This housing unit, it started off small, but it has grown gradually. My understanding is that initially it was funded by revenue that the AG's office had obtained through settlements and litigation. And this provided, I think, enough funding for at least one or maybe 1.5 full-time staff members initially, though I do believe that this office has grown a little bit since then. It's important to note that under this bill and to this day, the Attorney General has discretionary enforcement authority. So that means that they don't ever have to get involved with looking at a case unless they want to. And they generally, I think, prioritize cases where there's been systemic harm that's occurred or where their enforcement would have precedential deterrent benefits, but they don't generally get involved with every case or even the majority of complaints that they receive, is my understanding. No less, in some respects, this was really a watershed bill that expanded access to justice because it represents one of the few areas where the state has enforcement authority over landlord-tenant laws. And so in that sense, it's kind of similar to what mobile home park residents have through the state's enforcement program. Again, it's a little bit different because it is discretionary, but it is a state mechanism other than the courts that provide some degree of enforcement, at least in some areas. So, for example, I think one of the first, if not the very first instance of the Attorney General actually utilizing this legal authority, they were recently able to obtain a settlement on behalf of tenants who had been charged excessive and unauthorized fees. And this was in the news. So you can, if you search Colorado Attorney General Security Deposit Settlement, you can find a lot of information about that settlement. I think it was for $1 million. But it's historic because it was really the first case of its kind. So it will certainly be interesting to see if and how this housing unit continues to develop over time. Next slide, please. 2022 also saw the passage of House Bill 1287. And again, this is a Mobile Home Park Act bill that established some new protections for mobile home park residents. This bill initially spurred some considerable controversy because when it was introduced, it included a proposal that would have capped rent increases, lot rent increases for mobile home park residents. This was also reported on pretty widely in the news. Ultimately, there was a threat of a veto from the governor who did not support that policy. And so that portion of the bill was ultimately amended out before it was passed. No less, the final version that did pass still included a number of meaningful changes for park residents. So first, this bill provided, in some ways, more meaningful opportunities for mobile homeowners to purchase their park under that policy I described, opportunity to purchase. And it did this by expanding the time that's allotted to homeowners to make an offer from what was 90 days increased to 120 days. It also established certain tolling events that would pause that 120-day clock if there is a delay in obtaining financing or a delay in getting an inspection that is outside of the homeowner's control. It also includes tolling events if homeowners were to file a complaint about the sales process, or if they attempt to assign their opportunity to purchase rights to a nonprofit or public entity. If homeowners assign, excuse me, I really mean public entity, more so than nonprofits. But if homeowners do assign their opportunity to purchase rights to a public entity, so to a local government or potentially a housing authority, the bill provides those public entities with a right of first refusal, meaning that they are allowed to match the best offer that a park seller receives when they're trying to sell their park. And this would allow the public entity to purchase the park on behalf of the residents. This law also clarified what is required by park owners in order to engage in those good faith negotiations with homeowners who do want to make an offer. So this bill prohibits the seller, for example, from rejecting an offer because of the time period required for closing, or, and this is big, the method for financing the purchase. And the reason that's big is because a lot of parks are bought by national or international hedge funds, and they buy it with cash. And so it's very difficult for the park residents, for the homeowners, to compete with all cash offers. But under this bill, there's not supposed to be consideration of financing. I'm going to move quickly in the interest of time, because there's a lot in this bill. A lot of interesting stuff and new policies to explore. This bill allowed for assistance to displaced park residents if the park is closed or if the use of the park is changed, so it's no longer a park. If the park is being closed, then the homeowners who live there are entitled to some compensation, and that could include reimbursement for relocating their mobile home within 100 miles, or it could be a flat rate that they can get $7,500 if it's a single wide home, or $10,000 if it's a double wide home. Or if it's if it's an expensive mobile home, they can also receive the fair market value of the home as it's currently situated. And this applies again to homeowners, not to renters, people who are renting both the lot and renting the mobile home. Next, this bill also created some more options for enforcement of Colorado's Mobile Home Park Act. And specifically, it prohibits park owners from increasing rents if they have not registered with the state, or if they owe penalties to the state, or if they fail to comply with an order from the Division of Housing. In these circumstances, it temporarily prohibits rent increases until the park is brought back into lawful compliance. This bill also allowed the Office of the Attorney General to enforce Colorado's Mobile Home Park Act, and it authorized a greater range of penalties that the Division of Housing can order in response to legal violations. This bill also allowed homeowners to pursue non-frivolous claims against a park owner without incurring the risk of liability for that park owner's legal fees, and without being required to pay a bond into the court as a condition for bringing the lawsuit. This was actually a pretty big change, because we had seen a number of what we thought was meritorious claims that were not pursued because there was this huge risk of incurring attorney's fees, and the cost of getting into court were just too high. Also, and this was delayed, this only began recently on July 1st of this year, but this bill expanded who is allowed to access the dispute resolution program. And so it allows renters, people who are renting the mobile home and the lot, to file complaints. It also expanded that opportunity to nonprofits and to local governments. So local governments and nonprofits can now directly file complaints if they have concerns about MHPA violations. This bill also established some new penalties for when park owners might threaten a baseless or retaliatory eviction, or if they were to mislead a homeowner into signing a new lease agreement that isn't lawfully required, or if there's retaliation for residents who conduct organizing activities. This bill established some specific penalties. And it also strengthened some of the protections that were meant to prevent unreasonable interference with a homeowner's right to sell their house. So it expanded opportunities for people to be able to sell their mobile home to other potential park residents. There were a few other changes. I'm sorry, Lauren, I know I'm taking too long. So real quickly, there were some changes around the provision of alternative water when there's water disruptions. There was a policy requiring the retention of park records. There was a policy around giving park residents an opportunity to request a meeting with the park management, and a few others that we may not have time to go into full detail today. But I will just say collectively, this bill included a package of changes that really fundamentally reshaped some of the core rights under Colorado's Mobile Home Park Act. Next slide, please. All right, well, that brings us to 2023, which was an action-packed year for landlord-tenant bills, as you can see from the slide, with at least 7 bills passing that year that we would like to discuss today. This was, in contrast, I think, a relatively quieter year for mobile home park reforms, although there was one bill that passed, House Bill 1257, and we're not going to discuss that one in depth today, but I do want to mention it because it was a bill that addressed issues around water quality in mobile home parks, and that may be of interest to some of you. But otherwise, I'm excited to get into these bills. Next slide, please. So the first 2023 bill that I'm excited to discuss today is House Bill 1186. And this legislation provided both parties to an eviction, the landlord and the tenant, with an option of participating virtually. And this is a bill that at Poverty Law Project, we worked on in collaboration with partners at Colorado Children's Campaign, as well as others. There are really many reasons why a person, despite their best efforts, might be unable to participate in an eviction proceeding in person. And so these include barriers such as childcare, or a lack of transportation, or employment constraints, or sometimes having a disability can make it more difficult to appear in person at court. So what this bill sought to do is to utilize technology in order to strengthen due process and expand access to the courts by allowing both parties to participate virtually in an eviction proceeding. In fact, to my knowledge, I think Colorado may very well be the first state, and one of the few states still, whose legislature has guaranteed the ability to participate virtually in all stages of an eviction. The research that we found showed that when parties are able to participate virtually, the no-show rate, or the rate of people who automatically lose their case by default, lowers dramatically. There was one study in Arizona that found that the no-show rate in evictions fell from what was 40% down to only 13% when virtual participation became possible. In fact, here in Colorado, when this bill was introduced, the state estimated that there was nearly 8,000 households, which is roughly 20%-ish of all households that face eviction, that would now be able to participate and defend against the eviction because of this law allowing for virtual participation. So this was a game changer for many people, but also for us as legal aid providers, because it allows us to also now virtually represent people who are facing eviction in more rural parts of the state where we don't have an in-person presence. How does this bill work exactly? This bill allows either party and any witness, if there's a trial, to choose how they want to participate in the eviction, either in person, or it could be by video conference, or it could be by telephone. And if it's a video conference, that remote access is facilitated through a platform that's designated by the court. And I believe they currently use WebEx, but that might change in the future. If someone does elect to participate in a certain way, they can actually change their mind by contacting the court and selecting a different method of participation, provided that they do so at least 48 hours before their scheduled appearance. If it's within 48 hours of the appearance, it's actually at the court's discretion still. whether or not they approve or deny a requested change in someone's method of participation. Now, notably, this bill also allowed unrepresented parties, so those without the assistance of legal counsel, it allows them to file motions and submit documents electronically. And this was also a big deal because it was tough for people to take off of work and show up in court in person to file things if they were able to print them off and do that at all. Now, you might be wondering what happens if someone's participating virtually and then their internet dies or their phone dies? What happens if the power goes out? It's happened to me, hopefully not today during this presentation, but it is a legitimate concern. Fortunately, this bill did provide a process. It prohibits courts from entering a default automatic eviction if someone's unable to participate because of technological failures. And to that end, it also requires that the court make a reasonable effort to reestablish a connection if someone is disconnected by, let's say, calling them. If a person is disconnected during their virtual eviction and they aren't able to reestablish that connection, this bill instructed courts to then reschedule the hearing to be held in person at the first available date and no longer than a week out to the extent practicable. So the goal here is not to allow for a needless delay. And to that end, if someone does have tech issues that disrupts their virtual court appearance, they really only have one bite at the virtual apple. And the second time, they very well will have to show up in person. How do people know all this? That's a question. Under this bill, this information is required to be included on the eviction summons that the court gives. So courts will have to provide their contact information as well as some instructions on what to do if someone's technology is disrupted. Next slide, please. The next bill that I'm excited to discuss is Senate Bill 184. And this is a bill that was meant to do two things, really. The first is that it aligns tenant screening with the market realities in order to give tenants a more meaningful chance to find housing. And then secondly, this bill also clarifies that when a tenant experiences an eviction because of discrimination, that they can raise discrimination as a defense to the eviction. So this bill was introduced to give rental applicants who have limited incomes a more meaningful chance to be considered. As Lauren mentioned just a couple of minutes ago, there was legislation passed in 2020 that prohibited housing discrimination based on someone's source of income. So in other words, landlords should no longer deny someone for using a voucher. In practice, though, what we had seen is that some landlords circumvented this law, not by denying people based on their source of income, but based on the amount of their income. For example, by imposing minimum income requirements, requiring that someone earn 3 times or more the cost of rent, and denying people based on their credit scores. It's understandable, of course, why landlords are going to want to inquire about their tenants' financial solvency. Of course, there's an expectation that tenants meet their obligations to pay rent on time. But in some ways, by requiring a minimum amount of income, it wasn't necessarily reflective of how Colorado's rental market had changed in the recent past. In fact, many renters across the state do spend more than 3 times their income on housing. And of course, ideally, no one would have to do that, but that's just not the reality for most low-income Coloradans. There's been some data showing that nearly half of all renters spend more than a third of their income on housing. And I believe a quarter of tenants spend actually more than 50% of their income on housing in Colorado. And so as a result, this 3 times standard had priced many Coloradans out of housing, and it resulted in folks who were largely pushed either onto the streets or into substandard housing if they couldn't meet that 3 times and sometimes 3.5 or 4 times requirement. This bill addressed those issues in a couple of ways. First, for all renters, this bill prohibits landlords from inquiring about or considering a rental applicant's amount of income, except to confirm that the tenant's income equals or exceeds 200% of rent. So in other words, landlords can still consider someone's income, but only to confirm that they earn at least 2 times the cost of rent. Now, for tenants who are using a voucher, the landlord is, under this bill, is only allowed to consider whether their income equals 2 times their portion of rent. So for example, if a tenant's rent is, let's say, $1,000, but the voucher covers 900 of that rent, and the tenant pays 100, the landlord can still ask if the tenant earns at least $200 a month, which is 2 times their portion. Furthermore, and this is pretty big, for rental applicants who do have a voucher, the landlord cannot consider or inquire about their credit score or credit history. The idea here was that the voucher is a guaranteed income source, so in some ways it's really not appropriate to consider that credit history. And to my knowledge, Colorado, I believe, is the first state in the country that has limited consideration of someone's income to a 2 times multiplier. And I believe we're the only state, along with Washington, D.C., that prohibits consideration of credit history for people using a voucher. I also want to note that this bill defines income pretty broadly. So it's not just earned income or from employment or unearned income from benefits. It actually also includes cash assets that people have. So for people that may have either a very low or a fixed income or even no income, if they can demonstrate that they have sufficient cash reserves, that also can be used to satisfy the amount of income requirement. There's really no exceptions or carve-outs to this law, except that housing providers who are receiving funding from the government or from a nonprofit, they can still inquire about someone's finances for the purposes of determining whether the applicant qualifies for a subsidized unit. I'll note that this policy is generally enforceable through 2 means, either through a private cause of action, so a lawsuit, or it can also be enforced through an administrative complaint that's filed with Colorado Civil Rights Division. A person does not have to exhaust those administrative remedies before they can pursue the lawsuit. And if they are successful in pursuing a lawsuit, there are statutory penalties. These include $50 for an initial violation. And if the landlord doesn't fix or cure the violation, they may also be responsible for paying as much as $2,500, along with any actual damages or court costs and attorney's fees. Real quickly, this bill also included just a few other policy changes. It capped what can be charged as an allowable security deposit to not exceed more than 2 times the cost of 1 month's rent. That probably did not change industry practice that much. We rarely see security deposits that are more than 2 months rent, but they did happen occasionally, and this places a cap on those. And then again, this bill also clearly established that fair housing violations, so instances of discrimination, can also be raised as an affirmative defense to an eviction. Collectively, this bill really fundamentally changed the parameters of tenant screening in Colorado. And it also added this enforcement mechanism for discrimination. Next slide, please. The next bill I want to discuss is House Bill 1099, which was meant to help save tenants some money by allowing them to recycle a recent tenant screening report when they're applying for rental housing. So as many of you know, when a tenant applies for housing, they often spend anywhere from $50 to $100 in order to have their credit score pulled, their criminal background check, their reference check, and all the other information that a landlord might incur an expense when they're considering whether to rent to this person. If a person has to apply to multiple units, as many of our clients do, these fees quickly add up to a hefty amount, and it constitutes a significant financial burden. In fact, we have seen people exhaust their entire savings on just application fees alone. We've seen that happen. And so this bill is meant to alleviate that burden by allowing tenants the opportunity to repurpose a recent tenant screening report if certain conditions are met. And that's the kicker with this bill, is the fine print. Unfortunately, and this has been highlighted in some recent articles. I think the Colorado Sun may have had an article about this recently. But this law has not really worked as it was intended to work, because the conditions that have to be met to reuse a tenant screening report are very stringent. For example, the report has to be recent. It has to be within the last 30 days, and it has to include very specific information about their tenant and their rental history in order for the landlord to accept it. Some of that information is directly contradictory to the last bill I mentioned, 184, like your credit report. If you have a voucher, you shouldn't have to share your credit report under 184, but to reuse your tenant screening report, you do have to have that information included. And that creates kind of a catch-22. The biggest problem, though, in terms of making this law accessible, is that a landlord can still require that the report be provided directly, meaning not from the tenants, but from the credit reporting agency or from a credible third-party website. A lot of the credit reporting agencies don't do that, or they charge a fee, or they just don't do it full stop. And so there are many cases where there are these technological issues, and having the report sent from the right authority within the right amount of time, very few people, to my knowledge, have been able to take advantage of that policy. And so for these reasons, frankly, it would not surprise me if there was legislative interest in reforming this law and tweaking it so that the reports can be used more readily. However, there were a few other provisions in this bill that I think are worth noting. Specifically, this bill gave the Attorney General the legal authority to enforce the entire Rental Application Fairness Act. It also established some minimum penalties for when that Rental Application Fairness Act is violated. And those penalties largely mirrored the same ones I just described for Senate Bill 184. So that's $50 automatically for a violation, and potentially up to $2,500 if the violation remains uncured. In our practice, we still see violations of the Rental Application Fairness Act with some regularity, but I do believe that these new enforcement mechanisms, the penalties and the AG enforcement, it does give tenants a few more options for pursuing relief when they might be improperly screened out of rental consideration. With that, I will now turn things back to Lauren to finish our discussion of the bills from 2023.
Awesome. Thanks so much, Jack. Want to be mindful of time. I am seeing a lot of questions in the chat that are wonderful, and we want to get to them. We also want to spend a significant amount of time on our 2024 bills, on for-cause and habitability. So I'm going to breeze a little bit through these last 2023 ones. If you have any questions, throw them in the chat. We will answer them. Just want to save us some time so you can make sure we answer all the questions. So 1120 was a huge one in my mind. It provided additional protections for individuals who receive SSI, SSDI, and TANF in their eviction cases. So in practice, a landlord, when they serve a demand, they have to include an advisement about mediation. So saying if you receive SSI, SSDI, or TANF, then you may be entitled to mediation, so you need to let me know. So then the tenant lets the landlord know that they do receive one of those benefits and they would like to mediate. And then a mediation happens before an eviction is even filed to try to come to some agreement, whether it's non-payment or a lease violation or other situation going on. A neutral third party through the Office of Dispute Resolution conducts the mediation to see if the parties can work it out before an eviction case is filed. That should be at no cost to the tenant, and it should be scheduled whenever the landlord reaches out to ODR within, I believe it's 14 days. If the mediation is unsuccessful, then an eviction case can be filed, and an affidavit needs to be filed with the court asserting what happened in mediation, or that no resolution was reached, and therefore that's why they're here in front of the court. Additionally, if the tenant ends up having a judgment for possession enter against them, the legislator recognized that individuals who receive these benefits may have a harder time finding new housing, and that it's very important for their long-term stability for them to be able to find that housing before they move out. So it provides that if the tenant receives one of these benefits, like I mentioned earlier, the writ of restitution can be carried out 10 days after a judgment for possession. But here, if you receive one of these benefits, it's 30 days. So you get some additional time. Next, House Bill 23-1095 included some limitations on what can be included in lease agreements. For example, it set some new guardrails around attorney's fees in any eviction. It basically just doubled down and clarified that you do have to be the prevailing party, and there does need to be a fee shifting agreement that goes both ways in your lease in order to get any attorney's fees. Additionally, it limits the imposition of lease non-renewal fees. So damages if you decide to terminate your lease, and other third-party fees. So landlords can't make a profit if the tenant is paying the landlord to then pay the electricity company. The landlord can't make an exorbitant profit and for being that middleman. It prohibits leases from including waivers to jury trials, waivers to class actions, waivers to the implied covenant of good faith and fair dealing, and the implied covenant of quiet enjoyment. So if a lease does include any of those waivers, that clause is void and unenforceable because it does contradict with the law. And it additionally provides some clarity around what is rent for the purposes of eviction. So it's always been our understanding that a non-payment of rent eviction is for non-payment of rent. But this bill added some clarity of what rent is not. So utilities and other fees cannot be categorized as rent in the lease agreement. That would then allow the landlord to evict for non-payment of those other fees because they are named rent, even though they are, in fact, not necessarily so. Additionally, new habitability tweaks were made in 2023. Again, a huge overhaul was made in 2024 that Jack is going to talk in detail about. So I'm just going to skip over this. It was improved a little bit, and then a lot of things changed this year. And then lastly, there were some limitations on fees in regards to pets in residential housing. So first, it prohibited an insurer from considering the breed of the dog, saying, I'm not going to insure you if you have a pit bull, for example. Second, if a tenant is evicted, it put into place a process to care for those pets. So when the sheriffs were coming in the past, there wasn't really a process for what they should do with the pets if the tenant wasn't there, for example, and they left their pets. Here, the sheriffs, I believe, need to bring them to a local shelter and notify the tenant of where their animals are so that those pets are taken care of. Additionally, it caps pet deposits. So in addition to a security deposit, some landlords also charge a pet deposit because pets may cause additional damage. These pet deposits cannot exceed $300, and they have to be refundable. We were seeing prior to this non-refundable pet deposits of higher amounts, and so the legislature capped this. Additionally, some landlords charge pet rent in addition to human rent, or the rent for the tenants who are going to be living there. And this bill capped those amounts at either the greater of $35 per month or 1.5% of the monthly rent. Now we're going to hop into 2024. This was a big year as well. And so we are going to talk about each of these. I'm going to talk in detail about 1098, the for-cause bill, because that changed a lot and it's a little tricky to navigate. Jack's going to talk a lot about safe housing for residential tenants, Senate Bill 2494, about the habitability changes that were made. And then we're going to touch on the other ones a little bit. We're going to focus on those two mainly. So, for cause or just cause, we refer to it in both ways colloquially. It prohibits landlords from not renewing a lease without a valid legal reason, with exceptions. So this is a big process, and I have a few slides on it that we will walk through. Essentially, it puts some caps on non-renewal of leases. So in the past, if my landlord decided, okay, my lease was up on July 1st, that they didn't want to move forward in renewing the tenancy, they could just choose not to renew it. And then we would go our separate ways, or if I did not leave, they could file an eviction against me. That changes here in some situations. Some miscellaneous things that it included that are important in the eviction process is that lease violations must be material. Now, it was always implied in my understanding that a lease violation needed to be material. It would be odd to see an eviction for something super, super minor. For example, and I've never seen a lease like this, but if a lease says like you can't have a toaster and I had a toaster, and the reason for that was not like based in health and safety or something like that, that would be an unusual thing to see an eviction for. But it clarified here, kind of like 1095 clarified a lot of our procedures and understanding that they must be material lease violations in order to evict. It also importantly expanded access to justice for our non-English speaking community members. So demands for rent, for compliance with a lease provision, for notices to terminate tenancy, anything that would be pre-eviction filing to give the tenant notice or demand that they do something before an eviction case is filed, must be in a language that is the tenant's primary language if that is not English. So default, it can be in English. But if the landlord knows or has reason to know that their tenant's primary language is Spanish or Arabic, pardon me, or any other language, that demand must also be in that tenant's language so they can understand what they have to do. Additionally, it clarified personal service for those demands. So in the past, personal service had to be attempted, and if personal service could not be achieved, then the landlord could post it on the tenant's door in a conspicuous place. But this clarifies that personal service must be attempted twice on 2 separate days. So if I'm a landlord and I need to serve a demand on my tenant, I could go today and knock and wait, ring the doorbell, see if I'm able to get a hold of them to provide that personal service handed to them. And if they didn't answer, I wasn't able to get a hold of them, then I could come back tomorrow, do the same thing again, knock, wait, ring the doorbell, see if I'm able to achieve personal service. And at that point, if I am not able to, then I may post it in a conspicuous place on the tenant's residence, usually on the door. All right, so hopping into the meat of the bill. First step in the analysis, in my mind, is to determine when this does not apply. Because if for-cause protections do not apply, we just default to what we already knew and move along with that process. If they does apply, then we'll go into the for-cause world. So for-cause protections do not apply to temporary rentals for less than 30 days. So thinking like Airbnbs, other things like that. It does not apply to owner-occupied or master tenant-occupied units that are single-family home, duplex, or triplex. So owner-occupied would be, let's say I own a single-family home and I rent out a room in my single-family home to someone else. And similar theory with a master tenant. So if I'm renting out a single-family home and I rent out a bedroom. Additionally, these protections do not apply to employer-provided housing. As we've seen in a lot of these bills we've been talking about, employer-provided housing is an exception to a lot of these processes. It also does not apply to mobile homes that are owned by the person renting the lot space or rented to someone with a lease to own provision in their contract. And I believe that's because our Mobile Home Park Act has a lot of other protections for those individuals, so for cause would not apply to them. Additionally, and this is probably the biggest one, is that it does not apply to individuals who have not been tenants for 12 months. So if I just moved in here 3 months ago, for cause would not apply. Now, the language in the statute is very broad. And so I interpret it to mean that, let's say I just signed a new lease 3 months ago, but I have been living here for 3 years. I would qualify as a person who has been a tenant for 12 months. I have had a tenant-landlord relationship with my landlord for 3 years. So just because I just started a new lease 3 months ago does not mean this exception applies, and my landlord does not need to follow for cause. It also does not apply to unknown tenants. So if there is someone who the landlord has no lease with, has no reason to know that they are living there, has no landlord-tenant relationship with them, for cause protections would not apply. If for cause does apply, so if none of those exceptions are in play, the landlord can only choose not to renew a lease with 90 days notice for these specific 6 reasons. Now, if there's non-payment, if there's lease violation, if there's substantial violation, any of our other normal eviction processes apply, landlords can still utilize those. Not saying that you need to keep someone who has committed a substantial violation or multiple lease violations, or you have other legal bases to evict them. But aside from those, if you just want to choose not to renew a lease with someone, it needs to be for one of these 6 reasons, and you need to be able to demonstrate it. Now, each one has a lot of moving pieces, a lot of definitions and processes. I'm going to hit the high points, and then we're happy to chat about specific questions. So if the landlord wants to demolish or convert the use of the premises, they can do so, or they can non-renew if they give the tenant 90 days notice and are able to back up essentially their reason that they do want to demolish or convert the premises. If the landlord needs to make substantial repairs or renovations to the unit, with the exception that it can't be substantial repairs or renovations that are based in a complaint about the warranty of habitability, and the landlord has a lawful duty to make those repairs and renovations under the warranty of habitability. So if I complain to my landlord that my roof is falling in, that's a violation, or that's a breach potentially of the warranty of habitability, and I need you to repair it. They can't non-renew me because they want to make those repairs generally. If the landlord or a family member needs to move into the unit, they can choose to non-renew with the 90 days notice. Though if the landlord or their family member is active military, only 45-day notice is required. If the landlord is planning on and going to sell the premises, they could do so. Additionally, if the landlord offers a new lease term with reasonable terms, or a new lease agreement with reasonable terms, and the tenant refuses to sign it, then the landlord can move forward with non-renewing because they have offered to renew and the tenant just doesn't want to. And then lastly, if the tenant paid rent late 3 or more times during the lease. And now, just like all of these, there are some caveats. It's not just that I was 20 minutes late 3 different times, or I was a day late 3 different times in paying my rent. The landlord has to serve the demand for rent or possession. And then the tenant needs to not comply with that. So let's say tenant is late, landlord serves a 10-day demand. Tenant does not pay the amounts owed within those 10 days, then that would count as one late payment for the purposes of for cause. I know that was a whirlwind. And I see a lot of questions are going in the chat, so we will answer those when we get there. And I am going to hand this back over to Jack, I believe.
Thanks, Lauren. Before diving into the rest of our presentation, one quick housekeeping note. I am seeing a lot of really great and really thoughtful questions in the chat, which we really appreciate. I suspect we're not going to have time to answer all of these questions live today, and that's my fault. I'm sorry. I clearly must have inherited my father's tendency to be long-winded and verbose. But with that said, I do want to encourage you to please keep asking these questions in the chat. And what I would like to propose, if this sounds okay to Catherine and to Lauren, is for those questions that we aren't able to address today live, we are happy to follow up in writing with some of our thoughts. And then we can share that with you, Catherine, and hopefully you can ensure that those answers are provided to all of the attendees on this webinar today. So with that said, please do keep asking questions, and apologies for any delay that we might have in getting to those, but we are happy to try to answer all your questions if we can.
Absolutely. And one more note from me, Jack. I need to give this computer that I'm learning right now back. So I'm going to try my computer again. Catherine, would you be so kind as to pull up the slides again while I transition?
No problem.
Thank you.
Okay, while we do this, in the interest of time, I'll just briefly cover House Bill 1007. This is really a zoning law that prohibits local governments from restricting how many people can live in a rental unit based on family status. So there were at least several jurisdictions in Colorado that previously had different occupancy limits based on whether or not the residents were related. And this bill essentially says, no, that's not a valid criterion that they can take into account anymore. Occupancy can still be limited for safety reasons, for health reasons, if a place is too small to accommodate a certain size of people. But it's moving forward, it is no longer relevant whether or not there is a familial relationship between the residents. And so with that, Catherine, if you're able to jump ahead, I think 2 slides to Senate Bill 94. Thank you so much. So this is the next bill that we want to discuss from this previous year, Senate Bill 94, which amended Colorado's warranty of habitability. And again, this is the law that is meant to help people who are potentially experiencing unsafe or unhealthy living conditions. This was a big bill, and unfortunately, we don't have time today to cover every change that was included. However, if you're interested in a very in-depth presentation just on this topic, warranty of habitability, Senate Bill 94, please do reach out to us and let us know, because we do have some other materials that we've developed that are really thorough in terms of covering exactly what this bill changed. With that said, Senate Bill 94 went into effect fairly recently on May 3rd of this year. And collectively, it included some of the largest changes to Colorado's warranty of habitability since it was first passed into law. So to start with, this bill added some specific timeframes for a landlord to not only begin a repair, but also presumptively to complete that repair. And specifically, this bill requires that landlords commence reasonable remedial actions, meaning that they come up with a plan for addressing a habitability issue, generally within 72 hours of having notice. But I do want to note that's actually 24 hours in more serious cases when the potential habitability issue implicates serious health and safety risks. What's really different, and that used to be 96 hours, so it was lowered by a day. But what's really different from the previous law is that this bill established some presumptive timeframes for a landlord to actually complete the repair. Up until now, landlords were not bound to complete repairs under any particular time frame. The law just simply required that it be done within a reasonable amount of time, but that wasn't defined, and it wasn't really clear to either party what that meant. Under this new law, presumptively, most repairs should be completed within 14 days, or in those situations that are more emergent, when a condition interferes with someone's life, health, or safety, the repair must presumptively be done within 7 days. I say presumptively, and the reason why is because there are understandably going to be some repairs that are going to have to take longer. For example, elevator repairs are notoriously difficult because the parts are hard to find, especially for these elevators that go back to the 70s and 80s. And so a landlord who is making reasonable best efforts to fix something, it might still take more than 7 or 14 days. However, there is a presumption that most of these repairs should be done within those time frames. And if it takes longer, the burden shifts and it becomes the landlord's responsibility to demonstrate why they've been delayed for reasonable reasons that are outside of their control. For example, they might demonstrate that they have been unable to access the unit in order to fix the problem within that time span. Another change under Senate Bill 94 is around the notice that is required to the landlord from the tenant when there's a condition that requires their attention. Under Senate Bill 94, any type of written communication that would provide a landlord with a basis to substantially know that a condition exists or even that it may exist will count as valid notice. If it's in writing, it could be on the back of a napkin, but if it is in writing and it provides notice of a potential condition, that is sufficient. Now, the bill actually provides a non-exhaustive list of examples, including that the notice need not come directly from the tenant. It might come from a third party. If there's an inspector who raises a concern, or a neighbor, or anyone, a contractor working for the landlord who raises an issue, if it's in writing and it gives that substantial basis to know of a condition, that would trigger habitability, protections, and responsibilities. I also want to note that there's an exception to this written notice requirement, where if a landlord has allowed a tenant to report conditions verbally, for example, if they allow them to call a hotline, or if the lease says you can call and report this condition, that also counts as appropriate notice if there's been prior permission or acceptance of verbal notice. When a landlord does have notice that a condition exists, it triggers a responsibility for them to communicate with the tenant what the repair plan is, and again, to commence those repairs within the timeframes I just described. Another change in this bill is that Senate Bill 94 also addresses some of the circumstances and responsibilities of a landlord who might be required to provide alternative living accommodations. So again, this responsibility to provide a hotel, motel, alternative living, it's triggered only when there's a very serious condition that would interfere with someone's life, safety, or health. If it's a relatively minor condition, it does not trigger that responsibility. But when that occurs, the landlord is required to provide that comparable dwelling unit, and they have to provide that within 24 hours upon request from the tenant. I do want to stress, if a tenant is put up in a hotel because of a major habitability issue, they're still responsible for paying rent for the entire portion of time that they're being put up in a different place. Now, the alternative place that they're put in, it needs to be habitable, so it needs to be safe in its own right. It also needs to be accessible to a person who has a disability, and it should theoretically be within 5 miles of a person's residence. However, under this bill, it can be a little bit further, but still no further than 10 miles if there is a substantially less expensive option. And I will say that I think under this bill, there is some flexibility with where someone can be put up. It doesn't have to be a hotel. It could be an Airbnb, or it really could even be a different unit that the landlord has that is currently vacant. If a tenant does require these alternative accommodations and they're being put up somewhere else for more than 48 hours, this also triggers a few other responsibilities. So if a person is displaced for more than 2 days, they have to be put up somewhere where there is an oven and a refrigerator with a freezer, or alternatively, if there are not these kitchen appliances, then the person is entitled to a daily food per diem. And that per diem is equal to what the state sets for state employees who are doing intrastate travel, which I think right now is, I want to say $59 a day, unless that's changed recently. Now, in some cases, there may be repairs that take a long time to do. And under this bill, it anticipates those situations, and it provides some relief to landlords so that if a repair is going to take longer than 60 days to complete, the landlord has an option of terminating the tenancy and no longer providing alternative housing beyond those 60 days. However, to exercise that clause, there are some requirements the landlord has to navigate. They would have to provide notice in advance, they would have to wait out the 60 days, and they would have to fully refund a person's security deposit, which is meant to allow the tenant to have resources to find a new place since the tenancy is ending early. I don't expect most repairs take longer than 2 months, but it does happen, especially again with elevators was a big concern when this bill was being considered, because those can take notoriously long time to fix. Now, in terms of what conditions violate habitability requirements, this bill only made a few tweaks. So this was mostly a procedural bill, but it did require reasonable amounts of hot water that's sufficient for someone's personal hygiene. It requires trash to be collected at regularly scheduled intervals. It requires remediation of insect infestations. Formerly, insects were not necessarily considered pests, but this would include things like cockroaches. It also requires that elevators be maintained in good working order, and that it's available to people with disabilities. And this bill also establishes a list of conditions that are presumptively more serious. Again, these are the ones that would undermine health, safety of the tenants or the life of the tenant. And these are the ones that would require quicker remediation and potentially the hotel. It used to be that the law did not distinguish what conditions were more serious than others. And under this bill, they came out with a handful of conditions that are presumptively in the more serious category. And that was meant to provide clarity for both sides. Now, I want to just briefly talk about how Senate bill addressed cooling responsibilities. It does not require that landlords have to provide cooling devices. So nothing in this bill compels a landlord to provide an air conditioner or a fan. It still remains voluntary. However, if the landlord decides to provide a cooling instrument, or if it's required under the lease agreement and it breaks, then the landlord is responsible for repairing that cooling device. Also under this bill, a landlord cannot generally prohibit a tenant from installing their own portable cooling device. So that's a portable, meaning it doesn't require a permanent alteration to the unit, like a fan or a window AC. There is an exception if the use of someone's cooling device would pose a safety risk. So if it violates local building codes or the manufacturer's safety instructions for that device, or if a unit is just old and it doesn't have the electric capacity to accommodate everyone's cooling device, under these situations, it can still be limited. However, if a landlord does restrict the use of someone's portable cooling device, the bill would require that the landlord do 3 things. First, they have to prioritize the use of cooling devices for people that self-report having a disability that requires cooling. So if an apartment only has electric capacity to support a couple of ACs, priority would have to be given first to people who have a disability. Secondly, if the landlord does restrict the use of the portable cooling device, they have to disclose those restrictions in writing to a tenant and to a prospective tenant. And then lastly, when a landlord discloses these restrictions in writing, they also have to share whether or not there are any areas in the building or nearby that are going to be available and kept at a cool temperature when there's an extreme heat event. So this might, for example, be a one-time notice given at the beginning of a tenancy saying, in the event that there's an extreme heat event, you can seek refuge at this public recreation center or at this library, but it's meant to provide some basic information that potentially could save people's lives around where they can find cooling relief. I'm sorry that we're going fast now, but if we may move to the next slide. So the next bill I'd like to discuss is 1099, and this actually is still not effective. It becomes effective on November 1st of this year. And this is a bill that will eliminate the court fees that tenants have to pay in order to respond to an eviction. So previously, before this bill, and in fact, still currently, in order to participate in the court process and defend against the eviction, renters will have to pay the government an additional $80 as a filing fee just to submit a response. And of course, this is in addition to any other debts that the tenant might owe their landlord. Now, theoretically, there have been some renters who can try to get this fee waived, but that process is also difficult because it requires a lot of paperwork that is, in some cases, hard to obtain in order to demonstrate that they financially qualify for a fee waiver. So under this bill, 1099, that answer fee is going to go away. And furthermore, for pro se tenants, those who are not working with a lawyer, and if they have to file their response physically in person, they are also now able to have their mailing fees waived so that the court on their behalf will then mail a copy of their response to the eviction to the landlord, and the person doesn't have to pay the mailing cost and the printing cost. So this bill is really intended to help expand access to justice by allowing tenants greater opportunity to participate in the court process without having to pay additional fees. But I think we also, and advocates who worked on this, hope that this is a positive for landlords too, because the hope is that this will spare people that $80 that they can also then use to repay their landlord if they are still in debt. Next slide, please. All right, the very last bill today, before we open things up, if there's any time remaining, is 1294. And this is a bill that also fundamentally changed some aspects of Colorado's Mobile Home Park Act. So first, this bill allows people with limited proficiency in English to be able to obtain necessary interpretations and translations of documents so that they have a clearer understanding as to what their rights and responsibilities are, can better understand things like rent increase notices or eviction notices. Secondly, this bill also addressed rent to own or lease to own contracts when a person is paying an amount above and beyond rent with the expectation that they will eventually have an opportunity to purchase the mobile home. So what this bill did is it ensures transparency in those agreements and also allows for a reasonable refund if an agreement is terminated prematurely. And that's going to be helpful for people who in the past would have had the rugs pulled out from underneath in some situations where they lose all of their equity at the final hour because of a disagreement with the park owner or the homeowner. This bill also clarifies some policies around when a park is being sold while it's still out of compliance with the law. So to that end, it allows the Division of Housing to be able to temporarily suspend rent increases if a park is non-compliant. This bill also clarifies the authority of a court to order certain remedies when an eviction is ongoing, but the resident has filed an administrative complaint against the park owner. This bill also provided just some technical, but still very important clarifications, including the ability for residents to access a reasonable amount of water during disruptions, the opportunity to have a mailbox where there's USPS service, and then also this bill addressed the presumptive enforceability of certain park rules. And I'll end things here in the interest of time, but I also would want to encourage you to reach out to us if you have specific questions about this bill. So with apologies about our time management today, this does bring us to the end of our presentation, leaving us with a full 3 minutes to get to your questions. I am sorry that we aren't able to answer more live, but I do commit to reviewing all these questions that you've submitted and providing written responses. And I also would encourage you to reach out to us if you might find a one-on-one conversation with follow-up questions to be helpful. With that, Catherine, do you have some closing remarks, or is there still time for us to try to tackle a few questions?
I'm not sure. We do have quite a few questions, and I'm going to maybe use some time to try and I believe I can get them off of Zoom, but I want to make sure I capture them all to send to you. Just letting people know that if you are on my agency mailing list, I'm going to get the slides and the answers to you. And then if you've registered with your email address when you logged into Zoom, I am committed to, once we get your answers, Jack and Lauren, to getting the copies of those answers and the slides to everyone who's registered. Lauren, I don't know if you saw any questions out here that you'd like to address while we still have a minute or two.
Unfortunately, when I switched back to my computer, I lost the 20 other questions, but I do see one that is about habitability that maybe we can address, and then we can address the others in writing. And sorry, I'm keeping my video off so my computer doesn't restart again. But Jack, the question is, in light of repair maintenance timing requirement laws, and those having to do with housing tenants during large repairs, how does this relate to current and future HQS annual and special inspections? I'm guessing that's relating to inspections via or by the housing authority. And if that is incorrect, please correct me.
That's a good question, and I don't want to misspeak, so I would like to do a little due diligence and researching for my own sake, so I know exactly. But my understanding is that this law really didn't change what is required under federal HUD regulations. So for properties that are subject to a federal inspection, or even for that matter, there are certain local governments that require periodic inspections now. And I don't think this bill really changed responsibilities. There's a lot of overlap. So the conditions that are required to maintain state habitability, by and large, are going to be very similar, I think, to the ones that are required in an inspection. But there are a couple of differences. And I don't think this bill necessarily changed either federal or local requirements in terms of those inspections. With that, thank you, Catherine, for allowing us this opportunity. And thank you, Lauren. Thank you again for all these very thoughtful questions. And I'm sorry we didn't have more time to answer them now, but I'm hopeful and excited to continue this dialogue. And so please do reach out to us, and we will get our thoughts down in writing to be shared with this group as soon as possible.
Awesome. Thank you both. I'll get you those questions as soon as possible so you can spend a day answering them for us. Appreciate you. Thanks again for the slides too and the ability to share them. All right, I'm going to stop recording. And I'm going to be here for a little bit to try and